December 14th, 2012. I'm here with Matt. Matt has what's called a commercial driver's license, which is you think of over-the-road truckers, things like that. And after a fun bachelor party night, Matt did the right thing by taking cabs the whole night long. They were woken the next morning when his buddy's angry wife was mad about how much money was put on a credit card, and decided it was time to get back home fast. So I rode back at 9:30 in the morning, thinking he's fine by then. Was speeding because they had to get their butts back, and you were going over allegedly about 115 miles an hour.
Correct. Yeah.
And nobody on the roads at that time of the morning except for a state trooper who noticed them and
Easter morning
pulled them over, and then subsequently smelled alcohol on his breath. So in addition to hitting him with charging him with serious speed, reckless driving, he was then charged with 2 forms of DWI for being over the .08 limit. So we had filed our implied consent challenge, which is the challenge to the loss of the driving privileges and the driving record, and challenged the expansion of the stop. That is, whether the officer had the right to ask Matt to submit to field sobriety tests and to give him a roadside breath test. We certainly knew the officer had the right to pull him over, so he had reason for the traffic stop, but I didn't think he had enough reason to submit to field sobriety tests and to be arrested for DWI at that point in time. So that was the challenge, and we went to the implied consent hearing. The trooper was testifying, and halfway through the hearing, the trooper on cross-examination did admit that actually he suspected that Matt would be under the limit, but that because of the odor of the alcohol and the speeding, he thought he had enough of a basis to test for DWI.
Correct, yeah.
We prevailed at that hearing, so we were able to protect his driving privileges and driving record, which is his livelihood, but we still had to deal with the criminal case where he was charged with those 4 misdemeanor violations, and either the DWIs or the reckless driving or speed over 100 miles an hour would have been another 6-month revocation of driving privileges and could have led to the loss of your employment.
Yeah.
So we came to the criminal case, letting them know what happened in the implied consent, and were able to negotiate a resolution where it was just a failure to drive with due care, which will not affect your driving privileges, will keep your employment, and there's a minimal fine. It's not even a crime on your record. So tell us, you talked to another lawyer I know, kind of interviewing lawyers, and just tell people what it was like going through the process with us.
The process has been very good as far as you guys have kept me up to speed and let me know everything. Smooth as far as besides my worrying and wondering, but it was very good. Handled everything excellent. Yeah, I'm extremely happy with it, and obviously to be able to keep the job and be able to stay there working, it's been very good.
So a couple of pointers. Don't think that just because you test over the limit that you don't have a defense to DWI. It's quite the contrary.
Mm-hmm.
That's called expansion of the stop, and that's one of the many challenges there are to DWIs first. And then second, if you need any more information, you can always contact me at www.arrestedminnesota.com. My name is Ryan Pasiga. You can call the office at 612-339-5844. And I guess in addition to being a criminal defense lawyer, I can now add bachelor party lawyer to my repertoire.
Yes, and thank you.